you're talking about some massive undertaking of writing a memorandum or brief on the law, and then the judges will get that from both sides, and then they'll schedule it for a full argument in front of the court, in front of all the justices of the court, and render a decision.
Is that what you're referring to as the oral argument?
Yes.
That's that portion of it. Now, people can appeal civil cases, criminal cases. What's the difference in which courts they go to, and what's the difference in the level of appeals with them? With a civil case, I don't know, divorces, I don't know.
They both function the same way. On a criminal case, we have criminal cases that are heard in district court, misdemeanors.
Right.
You can appeal that, trial de novo,
Right.
within a couple days to the district.
District to Superior.
To Superior Court.
Right, and that means de novo, you get a brand new trial.
Yeah.
It's as if that first one never happened. We call it a free bite at the apple.
And if you lose in Superior Court, you go through the same process as David just described. You have to file, docket it with the Supreme Court, file your mini brief, and then take it further.
Right, depending on where the court sends you. Now, even on the show cause, there'll be a shorter argument, but you get to argue in front of those judges as to what your position is and why they should, if it's your appeal, hear the whole appeal or grant it in your favor.
One thing about appeals that's unique, if you have a small claims case, the plaintiff agrees by filing that small claim that they lose their right to appeal. So the only one who would be appealing that would be the defendant.
Right.
So the better option, if you think that you might want to have an appeal because there might be something else going on, is to do what?
File your case in either in district court.
District court in the first instance, not using the small claims
Correct.
calendar.
Correct.
Now, we were talking about the right to appeal, as Jackie just raised. It raised another interesting issue. Not every court there's an automatic right to appeal. You have to file what's called a writ of certiorari, which is a request for the Supreme Court to hear your appeal. Workers' comp, for example. In workers' compensation, there used to be a right of appeal, but it's an interesting history. When somebody got on workers' comp back in the day, if you will, they were on comp, and if they were then knocked off of comp, which could only happen after a hearing in front of the Workers' Compensation Commission at the time, then their comp would stop when the judge said it stops, except if they took an appeal. And you had an automatic right to an appeal. So there was a famous lawyer who had a long beard and rings on every finger who appealed every case. So in reaction to that, they took away the right of appeal automatically. Now you can only appeal by writ of certiorari.
I thought that there was no end to the number of times that you could appeal, or number of places, but apparently
there is.
There is.
There is. Yeah.
What about in criminal cases? Is there a level of what the cost or the fine might be or the sentencing might be that would determine what court it's going to and what set of appeals it's going to apply?
It depends on what court you're in. I don't think the amount of the sentence, the duration of the sentence, might be an appealable issue in and of itself.
Sure.
Rather than the judgment.
That's both. It could be both.
Yeah.
Because the sentence is part of the judgment.
Exactly.
Okay.
So again, if it's in district court, then you can appeal it over to Superior Court. Get satisfaction in Superior Court, then you go through the Supreme Court process.
And there's a right of appeal in that case to the Supreme Court to hear whatever your complaint with the Superior Court action is.
Harkening back to a topic that we had touched on sessions ago, where is the onus on, in which court is the onus on the defense, or I guess to make sure that there's a viable case? I guess, is it criminal? That means that the onus is on the prosecution to do his job, not on the defense to do hers. You're guilty until proven innocent.
We're talking now a little bit of burden of proof.
Preserving your right to appeal.
Yeah. Well, on the burden of proof issue,
That's with which?
If it's criminal, the state bears the burden of proving its criminal case against you by a beyond a reasonable doubt standard. And so the defendant could sit at the table, his table, and do nothing at trial. And if the state doesn't meet its burden of proof, it could simply rise at the end of the case and say, Your Honor, I ask that the case be dismissed. The state hasn't met its burden of proof. End of case. You don't have to say anything. And in fact, if you don't say anything, the court would give an instruction to the jury, if it's a jury trial, saying that the defendant bears no burden of proof here, so do not read anything into the fact that the defendant didn't put up a defense or didn't testify.
That's a good point, an interesting point.
Of course, we have double jeopardy issues, too.
Sure.
This
is a good time to...
If you're not guilty.
Well...
It's kind of a gray area, but...
Finding him not guilty, what rights to appeal does the state have?
That's right.
Yeah.
So you double jeopardy. You can't be tried twice for the same
Right.
crime.
But the state does have a right to appeal a finding of a mistake, what they would call a mistake by the judge in giving instructions or on applying the law and that type of thing.
Of course, one of the contentious issues has always been jury nullification, but I'm not sure we want to go down that path right at the moment. But I guess court-appointed attorneys for appeal, is that an automatic availability to all who want to appeal? And the reason I bring it up, I think we have time to discuss Blagojevich and Amanda Knox, someone who says, I'm indigent now, I don't have any money, I want to appeal my case. I'm entitled to a court-appointed lawyer. True, false, and when?
Well, in a criminal case, there's times where you're entitled to a defense. You know, as they say in reading the rights, you're entitled to an attorney. If you can't afford one, one will be appointed for you. Mm-hmm. That's not the same in civil cases. Civil cases, you don't have that right. If you want to bring a case, you pay for the case or you do it yourself. So with Blagojevich, if he's saying, I don't have the money now to pursue the appeal, and he would have had a public defender in the first instance, the public defender's office does have attorneys that handle appeals. The question is he entitled to have them handle an appeal if they didn't handle the case in the first instance? And he's in Illinois, so I'm not sure what the answer there would be.
And what about the infamous Whitey Bulger, who said, I guess he does have plenty of money, as they found it in his apartment, but they latched onto it.
Right.
So now he says, I am indigent,
Yep.
and
you
you will...
an attorney.
Right.
Right, and that's not at the appeal process. That's just at the first
level.
level.
Trial.
Right.
Yeah.
And so he said, as I understand it, give me back my money and I can afford to pay my own attorney.
And the best of them at that,
Right.
perhaps.
Yeah.
But in the instance where he's claiming that's all the money I had in the world, I have no other funds or resources, then the state would be responsible for appointing an attorney for him.
In the Blagojevich case, they're discussing the possibility of having an appeal, and as I understand it, part of it is that they weren't allowed to present all of the tapes, but only part of the tapes. Does that end up presenting what you refer to as a
Legal issue? Sure.
Yeah.
It's an interpretation of the rules of evidence. Many times the issues at a trial are whether or not the rules of evidence were complied with. Was there a mistake in a ruling by a judge in admitting certain evidence or not admitting certain evidence? So that is absolutely a ripe ground for appeal.
In watching those countless television shows about law cases, often you'll hear that they decided to not allow a certain part of testimony, a certain part of evidence.
That's happening right now in the Casey Anthony trial. And
that's where we've been, okay.
Okay, so they have, in fact, they have to ask that it be admitted for her defense, but also to preserve the right of appeal.
Yeah.
Because if it's denied, you have your right to appeal it if they get a unfavorable
We used to call
ruling.
it protecting the record.
Yes.
So in the old days, if you object...
Last week?
Yeah, no, even before that, like when I first began practicing.
Oh,
if you
okay.
objected at trial, the first thing you would have to do is objection. What's your objection? You state the objection. No, maybe it's hearsay, which is an out-of-court statement that they want to present. Judge, that shouldn't be allowed in. And then, after the judge ruled on it, if they ruled against you, you used to have to say exception. I'm taking exception to your ruling to preserve that entire record. Now it's objection. If they let it in anyway, you don't have to take those other steps. It's a waste of time. Mm-hmm. On the other hand, if there's evidence you're trying to put in that's not going in, then you would make what's called an offer of proof, where you would get out of the hearing of the jury so that you can put on the record, Judge, if I were allowed to present this evidence, this is what it would show and why it should go in, and that's how you preserve your right to appeal.
That's when you go to judges' chambers?
Sidebar, they call
Sidebar.
it.
We can make offers of proof in civil court as well.
Mm-hmm. Well, this is what I'm talking about, civil.
Yeah.
In fact, I had a trial one time, and we went up to the sidebar, and the attorney who's evidence I was objecting to said that he wanted to go in. The judge said, well, why should it go in? And he said, well, it's really important to me. Well, what's your legal argument? And he said, it's really, very important, it should go in. So she said, well, if there's no legal basis for it, I'm not letting it in. So when we went back to counsel table in front of the jury, he said, Judge, I'd like to make an offer of proof. And so then he went on to say what the evidence would say. I'm thinking he did it in front of the jury so they would hear it. So I was going to object to it, but I didn't because it wasn't going in anyway. And after the trial, the judge spoke to the jury, and they said, we're surprised that we ended up getting this case to decide. And the judge looked and said, why? They said, well, we thought it was going to settle. The other attorney wanted to make an offer, which is maybe one of the reasons why you should make the offer of proof at the sidebar.
This certainly presents the case for why we should be having a lawyer deal with this, because I'm not always sure that someone who is presenting their own cases would know how to do that or know what to do with that.
Well, it's complicated. It's a very complicated process. And you have to file certain documents within a certain amount of time.
You don't want to try a jury trial as a layperson. That would be like going, as we've talked about before, into surgery and operating on yourself.
Not a good idea.
Not a good idea.
But if you are there representing yourself, you're going to be treated just like an attorney, any other attorney. So you will be expected to know the rules of civil procedure, criminal procedure, and your rules of evidence.
And the other point in the possibility of appeal is that there might have been too many jurors allowed in to serve who may be biased. Now, when that jury was being selected or seated, wouldn't that have been the one and only time that you can say, I think he's biased, I think she's biased, they're not acceptable to me?
Well, when you're impaneling a jury, you have a certain number of challenges that you can issue to the jury, or jurors, individual jurors, as they're coming up. They're called preemptory challenges, just because you don't think they're going to be kind to your side of the case, you can ask that they be knocked off. You can also challenge for cause jurors. For example, if somebody is closely connected to one of the other people that's involved in the case, a lawyer or a doctor or litigant on the other side, you can say to the judge, there's a bias here, and ask the judge to not keep them on. Now, if the judge doesn't agree with you, that may be a grounds for appeal if you're out of preemptory challenges.
Well, it sounds like he may have a good couple of options there to do some appeal, regardless of what ultimately happens. And now, not even in this country, but Amanda Knox, certainly we've been hearing that story for, what did they say, 4 Christmases that she's been in jail. They are talking about, on the one level, there were certainly issues about how they are conducting trials, but that's in another country. But now it's also about DNA evidence, and that's a reason for them to have this set of appeals. Is that one of the strongest options that someone has when they're talking about appeal? That certainly is about different evidence and a way of looking at it, or how do you look at that as being a reason for appeal?
As I understand that, they disallowed the DNA evidence. And then on her appeal, she argued for her right to have this evidence brought into the record and have the DNA tested. So now that it's admissible, their argument is that there is not any DNA that can link her to the crime.
It's a different country, so they have different rules, different appeals. However, in the United States, there's a whole group of people dedicated to trying to free prisoners based on DNA evidence that the DNA was available, the testing wasn't available back when they were convicted.
A whole other set of issues to bring.
Yeah.
With less than a minute to go, I guess the other issue about this Amanda Knox that I wanted to just mention was that while they had a reason to have appeals, there's also now a discussion about one of the witnesses who claims that he saw them on a bus at Halloween, but it really wasn't Halloween. So this was essentially new testimony or different testimony or challenged testimony or disputed testimony. All of that becomes an option once you have an appeal. I mean, that's new information or new challenged information. That's okay in an appeal?
In the United States, in Rhode Island, I would say that if it was evidence that was available that hadn't been presented, it's not going to be grounds for an appeal. If it was evidence that wasn't available, newly discovered evidence, there are certain rules where you can apply for a new trial or things of that nature.
We thank you for tuning in. Please stay with us. Our discussions of legal matters continues. Thank you.